Welcome to my channel AI Reaction. In today's video, we are going react to family court case. But before then, today's credit goes to Court Watcher's channel for the video link in the description below.
So our office filed a motion to reopen along with a transfer and motion to consolidate. And I think and just procedurally, we did a hearing in this cause sometime in March or April. And we're just asking the court to transfer actually the Hayes cause, who has CEJ over this case, to the Caldwell cause, because that's where mother, in this case, Miss Garcia, and the child are currently living.
And that was for more of an explanation with the two causes, the Hayes one was the earlier in time that came first, the final order?
Yes, Judge. The Hayes case was in 2013, where it named the grandma as the custodial parent, and mom in this case as the non-custodial parent. However, Mr. Harper, he was a necessary party to the case, but he was never noticed of the 2013 case and wasn't in any of the final orders. So I guess what we're trying to do is we're trying to get all the parties in to Caldwell, because that's where the mom and the child are living right now, so that we can do final orders.
Oh, so you want to transfer it to Caldwell, not Hayes? I misunderstood your pleading, I think.
Yeah, and that may have been my fault, but since the child and the mother at this point do live in Caldwell, I think we do need to transfer it to Caldwell and not Hayes.
So the 13-0773 to be consolidated into this one, and can we continue in Caldwell?
Yes, Judge.
Okay. I guess that doesn't make much of a difference if we're all on Zoom anyway for right now. Okay.
Correct, Judge.
And is there an agreement on that, or there's not even an agreement on that?
So there's not an agreement on that. As far as I'm aware, Mr. Harper is not in agreement to do any sort of transfer, consolidate, or consolidation. And mom in this case is in agreement to it, and the state filed the motion, so obviously we're the ones moving for it.
And obviously the first one has the cause number in it. It was 2013, or they both do, and the second one was 2024.
As far as the final orders, Judge?
Yeah, or pleading.
Yes. So the final orders in suit affecting the parent-child relationship in Hayes, those were done July 11th, 2013. And then final orders were rendered by the court, but we never sent out like a written order in Caldwell in March. Let me see.
Wait, would you repeat that? What about?
Yeah. I'm trying to find the exact dates for you here.
Okay.
So we did final orders right in 2013, July 11th, 2013 in Hayes. And then we did, let me see. We did, you rendered oral orders, final oral orders. I believe it was April. Nope, that's not it. April 24th of 2024. No. I'm so sorry, Judge. It was March 13th of 2025 when you rendered final orders in Caldwell as well. And that's for the petition to establish the parent-child relationship between Mr. Harper and the child.
And I haven't signed that one for some reason. I don't remember why, but
so we didn't send out orders, Judge, because at the time Hayes still has CEJ over this case.
You figured that out before the hearing. I mean, after the hearing, but before the order to be submitted.
Yes, Judge.
Yeah. Well, I'm glad something happened. Should have happened. Okay. So what does that mean with respect to, the Caldwell County order that I haven't signed?
So I think at this point, what we want to do is transfer the case from Hayes to Caldwell, so that we can all do a final order as it pertains to, I believe, just the back pay child support in this case because the child has turned 18.
To complicate matters further, okay. When does she turn 18?
I'm not
turned
sure. Go ahead.
January 8th.
Oh, it just happened January.
Yeah.
And she's out of high school now in
She
May?
just graduated about 2 weeks ago.
Okay. Okay, then I guess I'll hear from the witnesses. I gotta make some legal decisions whether or not people agree because that's my job. And we'll see where that takes us. But I assume we're not gonna complicate this. We're not gonna enter the final order. We're gonna just start over with Mr. Harper present. Ms. Teague, that's what you're gonna be asking.
Yes, you want me to go through some testimony on back pay child support
No, I'm gonna
or
start
the
with
transfer?
consolidation. Yeah, the transfer and consolidation, since you told me that was not agreed to. And
Yes, Judge.
I do on the merits side, depends on what I do on the transfer. If I transferred it, I shouldn't be able to hear it today. The cases won't be together yet, or you're
Yeah, so I'm thinking today we just get a ruling on whether the case can be transferred. And then we'll come back and do a final order, maybe at a later setting.
okay. This is a new one for me, so let's see what happens. Ms. Teague, you want to call witnesses?
Yes, I'm gonna call Miss Garcia.
Yes.
Miss Garcia, can you state your full name for the record?
Dolores Mary Garcia.
Okay. Do you understand the motions that have been filed in this case?
Yes, ma'am.
Okay. And are you in agreement to a transfer of your Hayes case to Caldwell?
Yes, I am.
Okay. And are you in agreement to consolidating your Hayes case once transferred into this case?
Yes, I am.
Okay. Nothing further for Miss Garcia, Judge.
Okay, the next witness.
All right, I'm gonna call Mr. Harper.
Yes, ma'am.
Mr. Harper, can you state your full name for the record?
Absolutely. Londale Dwayne Harper.
Okay. And do you understand the motions that have been filed in this case?
Yes, ma'am.
Okay. And are you in agreement to the transfer of the prior Hayes case into the transfer of the Hayes cause to Caldwell?
No, ma'am.
Okay. And why are you not in agreement to that?
Because during that time back in I believe you said 2013, 2014, I was unaware of any of this. I wasn't given the opportunity, I wasn't updated, I wasn't located, I had no part in anything. To consolidate something that I believe I was unaware of or given the opportunity to even be included in.
Okay. And you understand that that you were considered a necessary party to the Hayes case?
I am now aware of that
Okay.
you made me aware that there was something that transpired back in 2013, 2014.
Okay. And you understand that at the last setting, in Caldwell County, judge did establish the parent-child relationship between you and your child?
Are you talking?
Now,
You're talking about the most recent one, correct, Ms. Teague?
Yes, Judge, the one from March of 2025.
is that directed towards me?
Yes,
Correct.
Mr. Harper.
Okay. Yes, I do understand what transpired, but I also understand there were some things that were missed prior to our hearing.
Okay.
Some things that were not brought up or not seen prior to.
Okay. And notwithstanding those issues, you do understand that you have a duty of support toward your child?
I absolutely agree. I absolutely agree 100%. But I also want to, have this. Go ahead. I'm sorry.
I'm sorry, repeat what you said.
Could you repeat what you said one more time for me?
Oh, yes. I asked, you understand that you have a duty of support toward your child?
Yes, ma'am.
Um, and you're still not in agreement to transfer the Hayes case over to Caldwell so that that can be established? And
I
then
don't want
so that you can pay some. Go ahead.
I would not like to consolidate, if that's what you're asking.
I don't know if it's,
I'm sorry,
I don't know if it's, I'm so sorry.
it
I don't
my-
know if it's my computer or your computer, but you're breaking up. Can you repeat what you just said?
Yes, I would not like to consolidate both cases into one. I'd like to keep them separate as they were.
Okay. Nothing further, Judge.
Okay, you may not be seeing this from my perspective, obviously, because you haven't done this and you're not aware of some laws and stuff. But usually, when there's the same parents and same child, we can't have two cases because there can only be one county, one case that has continuing exclusive jurisdiction. Right now, we prevented the problem, a huge problem, of having two counties because I didn't sign the order because I wasn't really aware or made aware till now that this other case existed. So it started without you, and sometimes because we have no choice if there for some reason you weren't around or they couldn't find you or whatever. And I don't know, you can dispute it all you want, but it doesn't matter. In 2013, if grandma had the child and the state was providing some kind of benefit, which could have been Medicaid or TANF or something, they had the right to bring the case, and all we had was grandma and mom. Usually the orders I sign at that point in time with the other necessary party, the other parent, the father, is not present or can't be located or whatever. We enter those orders without prejudice to you, so that you do have the opportunity to come in at some later date and say your piece or get your part of the pie or obligations, duties, all that. But it took a long time. And now here we are. The child was a certain age and now she's emancipated. And now I can't go backwards and give you custody, give you visitation, give you retroactive visitation, do any of that. And actually, Ms. Garcia doesn't have the child support rights. Her mother does, because the order says grandma has custody and child support is owed from mom to grandma because you weren't there. So we didn't order child support against you. So now to fix this mess, legal mess, nothing personal, legal mess is just that we put the cases together. So there's not two conservators, two primary conservators in two different causes, because that makes no legal sense. And if I don't put them together and then modify the orders, they stand alone, and that's not right for law. I'm not allowed to do that. Nobody's allowed to do that. And thank goodness the state caught it in time. And then it gives me the way to fix it, even if grandma's here because she's no longer necessary, but you are here because you are necessary. But it really, the way I see it, it kind of undoes or voids that order of march that I rendered orally but didn't sign. So now that goes away and we kind of start anew, but still under the same pleading. And it has to be one court. Like a lot of times people argue about, no, I don't want to drive to that other county. It should be in my county. This is where it was, blah, 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 blah. But we're on Zoom, so that's less of an issue. And Caldwell and Hayes are hardly that far apart. So that shouldn't be a real concern. So.
Judge, may I ask a question?
Yes, sir, you may.
Thank you so much. So back in 2014, was I not mentioned as a father? 2013, did y'all attempt to locate did anyone attempt, was I mentioned?
You can't say you all include me because I don't bring these lawsuits. I only hear the lawsuits.
Yes,
I know I'm not offended. I'm just
I'm sorry. Judge.
trying to make sure you understand. I had nothing to do with it other than till it gets here. Now, the state, for whatever reason, the way I've seen the pleadings, they usually do say who the mother and the father and the grandmother is the custodial parent if she had the child and got Medicaid for the child at that point in time, whatever this, I'm just guessing at that because that's one of the main reasons that those kind of cases come to court. They would have probably named you. I'd have to look at the file and I don't have that in front of me right now because I'm not
Because you're
Caldwell.
not over that one. I get you. I'm so
Well, I'm
sorry
over
about
that one, but I'm not in Caldwell County to pull the manual files because they don't have electronic files for me to look at. But the state has copies of everything, and if I need them to look something up or tell me something, they can. So I'm not worried about that part. But
Okay.
they normally do have the pleading who the custodial parent is. That would have been grandma. The non-custodial parent at that point was Miss Garcia because she didn't have possession, I guess. And then they probably would have named you and probably said something that you weren't able to be located. And then they tried and they couldn't find you, or they didn't find you, or you weren't around. I don't have a clue, but they didn't get you legally served to get to court in time for the order between Ms. Garcia and her mother. And I assume it was her mother. So what I said about the court usually enters orders without prejudice to the parent that wasn't there, that means that you could have come in earlier and undone the whole thing and asked for custody yourself, or had to try to modify it, or they probably would have counterfiled and asked you for child support if the child wasn't living with you. But we could have done everything that you're entitled to, which is visitation, all that. But for some reason, this case didn't come up till your child's older. And by the time we get to court, she's 18, and now she's graduated. Now she's an adult. But we still have some rights to deal with, which is the child support rights. Under the original order, grandma got all the child support from mom, and there was no child support order ordered on you until March of this year. And then I'm not signing that thing. It's like starting over against you now that we know. And I'm not sure why you weren't in court in March. Was that a default, Ms. Teague, or was that
No,
you were
No,
there?
he was there, Judge.
Okay, but it was a contested hearing?
Yes, it
Yeah.
was.
Well, even if I did all that, I'd probably have to redo it now that I know there's a third party. Yeah. Geez. So I'm trying to give you enough information to understand so that you understand what I do is not that I didn't hear you, I didn't listen to you, but that there's laws out there that you're not aware of, including there can't be two cases for the same kid or the same parents. That's the main one. There's only
so
one.
how
Yes, sir. Go ahead.
so how is there two cases with the same child? That's my question. I don't understand if this
I couldn't fathom an answer. I couldn't even begin to guess. I'll tell you, if you want to follow it up, you have the right to go to the AG's office and talk to supervisors and get answers, but good luck. We have thousands of cases, and it happens. I've seen it happen, but we usually catch it quicker before whatever. But I have seen a lot of cases where parents, for some reason, weren't around and they couldn't find them. So we go forward with what we have, the grandmother, the mother. That's all we have. That's all we can do. And you weren't ordered to pay child support. You weren't doing anything. Here it is. That's a lot of years later. And now I can't order back child support back 10 years or to her birth. The law says only 4 years prior to the filing of the suit. So in a way, well, you may not have gotten any visitation, but you also weren't obligated to pay child support for that time period before they filed this one on you. Ms. Garcia, you had your hand up. You want to say something? Go ahead.
I can explain if necessary. I got incarcerated in 2012. My mother got custody. My daughter had food stamps and Medicaid. So he was mentioned. We just did not have information on him. I was blocked. My mother did give his name. They just couldn't find him. We didn't know where he lived. Date of birth, we didn't know anything, so that was complicated. But yes, that was why that child support was in order, because I did get incarcerated for 4 years, and he was aware.
Okay, that explains a lot. So kids are important. You got to do stuff whether parents are available or not, whether you think you're available and they don't find you, but they tried within their sources and they didn't find you. They didn't find you. We had to go do something so the child could have what the child needed. Now, at any point in time, had you discovered you could have jumped in the lawsuit or filed a new lawsuit or appealed that lawsuit or done something, but here we are way later and in a whole different situation.
Yes, ma'am.
So just what county do you reside in, Mr. Harper?
Tarrant County.
You're in Tarrant. So if I did this by Zoom, it's not going to harm you, whether it's in Hayes or Caldwell.
No, it would not.
Would you?
I just felt like I wanted to keep it consolidated. I was, set on. We had previously discussed what the plan was, what we were going to do, and now it seems like a whole nother. We have to start all the way over due to.
Well, yeah, yes and no. I can't sign that order, but if y'all, well, no, I could hear it all over again. But if y'all agree and to what I ordered, then I wouldn't have to hear it all over again, and we could just go forward on that. But I can't do that today because the cases aren't put together yet, and there's not one county and one cause number yet until I make that decision and let it follow, let the paperwork follow, and then set it for the merits hearing. So your big deal is you didn't want to undo what was done already, correct?
I mean that, and I just feel like there's some holes. I'm just not understanding everything.
What part?
Not everything in general. I just because because we had agreed on something. Okay, we went to court. I went to multiple court dates. Then there was a motion to vacate. Then I'm notified that there was another child support that was on Seneda. Then I'm notified that she wasn't the legal guardian when she put in for child support, so she didn't have the rights for the child support when she put in for child support. So that's why I was vacated. So I'm just trying to understand everything in general and as a whole, holistically. Just a little confused on how everything transpired. It just
Well, you just
I don't
heard
know.
kid was with mom goes to jail, somebody's got to have custody, and if it's not a parent and you didn't step up or figure it out or jump in, and they said they couldn't find you, I had to do something. You
I
got
wasn't
that. You weren't aware.
was
Uh,
not.
I don't know how to answer that one because I
All
don't know
right.
the facts of that it's water under the bridge really. But
Yeah.
now to fix it legally. So the motion to vacate was so that I don't sign the last order because there's a new order. There's not a new order. The old order is the one that we have to modify and
And Judge, I will jump in. We were gonna do a motion to vacate, but I don't think that was ever sent out because the order from March was never signed.
correct.
So that instead of the motion to vacate that Mr. Harper is talking about, we did file what's in the court file now to try to at least preserve some part of your ruling. Um, and I will clarify now that the child is 18, we don't really need to have a full hearing. It would just be on the issue of the back pay child support because at this point, the conservatorship and the visitation and the child support and medical support aren't at issue because she's emancipated.
Yeah.
Oh
What
no.
complication? We lost him. Jeez. What else can go wrong today? So we did wait, and it's just been a few minutes. So, Ms. Teague, or you were talking, weren't you, sir, about the motion to vacate, and Ms. Teague was addressing that. I looked at my notes. I do have that March docket. I was made aware after the fact that of the prior order, so I was asked not to sign that order purposefully, so that wouldn't complicate the issue till we got you here and we got y'all back here and figured it out. Okay, Ms. Teague, did you have any other evidence to present or any other questions to ask?
No, Judge. I just have a quick closing.
Well, then go ahead with closing.
Okay, so the state just requests that the Hayes cause be transferred to Caldwell. And then we rehear this case on the issue of the back pay child support. Dad was considered a necessary party in the 2013 case, and just because he was not a part of that proceeding doesn't preclude him from paying some child support for his child or having a duty of support toward his child.
And I think he didn't object to that. And if I looked at the request made, there was some back pay ordered and current pay ordered or what have you. But now it's
Yes.
have to start over with a new set of facts. Okay, Ms. Garcia, you said you didn't have any opposition to what the state's asking for me to put the cases together and that they go forward in Caldwell?
Yes, ma'am.
Okay, and your best legal argument, Mr. Harper, for why I should not do that? Because to me, it's just an administrative thing, a legal thing. Put the case all in one file, so all the proceedings and everything are in the same file for the same child, no matter who the parties were at what point in time. So why should I not do that, Mr. Harper?
Well, I mean, I just read the document that said that if I wanted to consolidate it or not, and that feel like South the best.
I'm losing you. You need to stay close to the microphone. I heard.
I'm sorry. So
I
I
can hear
just
you.
okay, yes, ma'am. I just felt like we had already done all of this. It feels like a restart. Consolidating, going back over what happened then and what happened in 2023. But if that's what the courts have deemed, then what can I do? I got the note that said I had the choice whether to consolidate or not. It was under my best interest, I assume, to not consolidate. That's
Well, I'm not so sure where you got that information or that that's even true. It's just a legal thing to put the cases together. Now, what I do next time, now that you are participating, and I assume you will be coming back for whatever reset I give you, so we can take care of business, I will consider what I've already done, whether you agree to or want that to continue or not, or we roll it all over into back pay or why it should be different. And Ms. Garcia will have that same opportunity to argue whatever. It's not just what one person wants, but when you don't agree, I get to decide it. And yes, you have every right to not agree and then come into court and see what the court does. But
yes,
on your issue, there's not a whole lot that I I can't grant you that. I've got to put the cases together. I wouldn't be doing my job, even if you don't quite understand it, Mr. Harper. Okay.
yes, ma'am.
So I'll see you back here. Did you give me a reset date before I rule completely, Miss Teague?
I don't have one in front of me, but I can look it up really quickly, Judge.
Everybody said they wanted to come back by Zoom. I understand.
Yes, ma'am.
Yes, Judge.
So we've got it's going to be a Caldwell day. We got 2 Caldwell dockets per month for the rest of the year.
Yeah,
And
not
you-
many to choose from.
yeah, there's a whole nother complication too. We don't want to go too far on this one. Do you have any light dockets along the way with your transformation with your new computer, Ms. Teague?
Yes, I'm gonna double check for you right now, Judge.
Okay. I'd pick a date for you, but I know you might object, so let me let you pick it for me.
You might have to go into August. August 12th is a pretty light day, and that is a Caldwell Zoom docket.
Okay.
That is kind of far. Let me check
At
one more.
8:30, or do you have already settings at 8:30 or 10:30?
We can do 10:30, Judge, if that works.
Does that work for you, Mr. Harper, if you're not first thing, but you're mid-morning?
Yes, ma'am.
Does that work for you, Ms. Garcia?
Yes, it does.
Okay, thank you. Then having heard the evidence and arguments, I will consolidate the 2 cases and transfer them, and it'd be under the Caldwell cause number and in Caldwell County with a reset to August 12th at 10:30 a.m. And by Zoom, it's going to be the same Zoom ID. So it's just the legalities of putting the cases together, come back. And I don't know if y'all talk or not, you're not required to, but whatever I did or whatever your positions were, if you want to keep the same, we'll talk about it and translate that. But now I can't formally put a visitation order. The child's now 18. She's an adult, so it's up to you and her, Mr. Harper, to figure it out on your own now that she's an adult. But the only issues are child support. Well, actually back child support. And so I'll see what I did and figure out what y'all want at that point and try to make the best decision I can. Of course, if y'all reach that best decision for me, then I don't have to decide it. If y'all have an agreement, I'd be happy to entertain that as well. Ms. Teague, do you need them for anything else?
No, Judge. I'll just let them know that I will draft the order today and send it out via DocuSign.
Okay, this has happened before. You didn't get it because it was stopped in midpoint. So the state's drafting the order. This one will go through to your emails. Pay attention. Anything coming in from the Texas Office of the Attorney General is this proposed order. So I'll ask you to review it and sign it. Mr. Harper, if you don't want to sign it, you don't have to. You still disagree with it. However, it will be my order that I'm rendering today. So it's my decision with or without check. Okay.
Yes, ma'am.
I'll give it a week. So by next Tuesday, if the state will turn it in, if you all have not signed it by Monday of next week. Any questions, sir?
No, ma'am.
Any questions, ma'am, Ms. Garcia?
No, ma'am.
Then thank you, and let's start over in July, no, excuse me, in August 12th at 8:30. Excuse me, I got it all wrong. August 12th at 10:30. I talked too fast and my brain's already on early mode. So you're on legal notice just because it's not in writing yet, you're gonna get it. However, right now, even if you don't get it or you don't sign off on it, this gives you legal notice to be here August 12th at 10:30 for this case with the same Zoom.